Okay, everyone in the audience, welcome to the Elder Law Committee of the Beverly Hills Bar Association. I'm Terry Maggedy, the chairman of our group. And the first thing, now normally the first thing I do is thank our sponsors, but also just right in front of us, it looks like we have a great trip to Scotland planned. So if you're interested in that, you could email the bar about that program. But first, I'm going to thank our sponsors because they're responsible for us being able to make this happen. The first sponsor is Nancy Sanborn and the Sanborn team. Nancy I've known for many years. Nancy and her real estate brokerage are specialists in our areas. Specialists in probate sales, sales with trust, sales with conservatorships, sales involving older people. And we want to thank Nancy and the Sanborn team for being our sponsors for a very long time. And our sponsor also is the person you see right in front of you right now, Arik Gadish, who will tell you about her company.
Thanks, Terry. Hi, everyone. On March 9th, I'll be presenting a webinar here at the Beverly Hills Bar titled Mistakes That Real Estate Agents Make That Can Cost You and Your Clients. That's at 12:30 p.m. Please join me. The link to register will be in the chat box. I'll be discussing various errors that probate and trust agents are making. Join me to learn how to correct them to protect your and your client's best interests and minimize liability. On a different note, if any of you need help with the disposition of any real estate assets, commercial or residential, please let me know. And for those of you with properties in an estate or trust that don't have sufficient funds to handle a clear out, cleanup, and or a renovation, please reach out to me. My team can help. Enjoy your program, and back to you, Terry.
Thank you, Arit. Our next sponsor is Glen Oaks Escrow, and that's the principal is Marcine Klein. Glen Oaks Escrow is another company that specializes in our field. Probates, trusts, conservatorships. I've used them before on a very complicated case, and they did a great job. So thank you, Glen Oaks Escrow and Marcine. Now we're up on the screen with them for being our sponsor. Our next sponsor is California Title Company. California Title Company is another vendor that works in our space of probates, conservatorships, trust sales. Just so happens I have a matter with them right now too. So thank you for being our sponsor, California Title Company. And our last but not least sponsor is Manufacturers Bank, a bank that's cut out a niche area in our space as well for conservatorships, fiduciaries, trust work, probates. Thank you, Manufacturers Bank, for being our sponsor. And our next program to put on your calendar here for the Elder Law Committee is April 5, and we're going to hear from Janice Cohen. Title is going to be Baby Boomers Aging in Southern California, the important role of the proprietary jumbo reverse mortgage. And from time to time, we've had people over the years, attorneys, brokers, talking about reverse mortgages. And these aren't just like general discussions. They're in keeping with what we're all about, like niche areas, even within the reverse mortgage field. And this one's going to be about proprietary jumbo reverse mortgages, which is something important in a state or a region like ours where we have highly valued real estate. And now I'd like to introduce our speaker for today, Bob King. Bob and I, we were chatting before our program, known each other a very long time. In fact, Bob spoke to our group about 17, 18 years ago, something like that.
Actually, I went back, Terry. It was 2009. That's
maybe
when I spoke.
Longer. Okay, we've known each other. We've known each other and worked together a very long time. And Bob is great, and he's really developed just a great niche that's like it's so important. I mean, if you're working in the field of fiduciaries and elder law, I mean, hiring caregivers. So it's like critical. So now I'm going to turn it over to you, Bob, for in-home caregivers, the advantages of hiring legally and the consequences of hiring under the table.
Thank you very much. Appreciate it. Terry, thank you for your hospitality and the invitation to be here. It's always a pleasure to be with this group. And I've spoken in 2009, and then I did an update in 2013. So given it's 9 years later, it's probably about this time, right?
We can use a refresher course, I'm sure.
And it's really funny because we get so many referrals from elder law attorneys, fiduciaries, conservators, trustees, because you're the frontline people. All of you are the ones who get involved in a matter, and then it's like turning over a rock, and you're like, oh, there's been a caregiver who's living in the home for 10 years, and we've just 1099'd her, so I'm sure there won't be a problem with that. Right. So anyway, I want to encourage everyone to chat in whenever they want. Listening to me talk for an hour is, I think, the literal definition of intentional infliction of emotional distress. So please, let's break that up with your questions at any time. Chat in or raise your hand, or somehow I will try and monitor that. Jose is awesome, and he's going to be the guy advancing the slides, and I'm happy to talk about what I'm talking about or whatever you want to talk about. This is truly sort of Stump the Lawyer. You got a little less than an hour with me, and I'm going to try and answer all your questions. Just so all of you know, I'm an employment attorney, and I specialize in working with home care agencies, nanny agencies, and family employers. So we started our law firm 19 years ago because I worked for a big firm at the time and had big firm clients, but we had our daughter and we hired a nanny, and I was determined to do it legally. And I couldn't find anybody who knew all the legal and tax issues of employing someone in their home. And so I learned it, and I said, there's going to be a market for this. And then fast forward, people started saying, I'm not hiring a nanny, I'm hiring a caregiver for my mom or my dad. Can you help me with that? And we said, sure. You know, the rules are the same, whether it's a nanny or a caregiver. And then we had home care agencies and nanny agencies contact us and say, you actually understand our business. Can you help us with our legal issues? And we said, sure. Now, the irony of Legally Nanny, and again, I know we have a funny name, is that now we probably do 90%, 95% of our work in home care. So people tell us we should rename ourselves Legally Granny or whatever it may be. But the home care is the space that we are most prevalent in right now. So Jose, why don't we start? Why don't we go to the next slide, please? Okay, so I have a lot of information and I speak quickly. So tell me to slow down, chat in as you like. But I need to sound like a lawyer briefly. It will be painful, but again, we'll make it as quick as possible. I am here providing you with information. I am not intending to provide you with specific legal advice to your particular situation. I can do that if you'd like me to, but that's not in a recorded webinar filled with all of our best friends, okay? Oh, and in fact, hey, Jose, can we just go back just for 1 second, please? Just go back to that first screen. There you go, great, thanks. I'm gonna take a picture of this because all of you are gonna be on our social media. So I just, I think I did that okay, but if not, hold on. Because it doesn't happen these days unless you do this on social media. So here we are, and all right, now we're good. Okay, Jose, let's go 2 slides in, please. Okay, so for all of you on this webinar, there are 2 types of home care. There's hiring through a home care agency, and there's a direct hire by a family. I am not in this presentation talking about hiring through an agency. That's a terrific way to go. If you want a turnkey solution, by all means, hire a home care agency, and you will not have to deal with any of the issues that I am discussing here in this in this presentation. Okay, they will handle all of it for you. There's a cost to doing it. You know, my analogy is everybody has to do their taxes. If you're a masochist like me and sort of like doing your own taxes, you're going to use TurboTax and do that. This presentation is for those people who are the TurboTax sort of people. If you are the person who wants to dump the shoebox full of receipts on your accountant's desk and say you deal with it, by all means, use a home care agency. They are experts at this. They know what they're doing, and they will handle all of this for you. I say that I represent literally hundreds, if not thousands, of home care agencies nationwide, primarily here in California, and they're excellent. And I'm going to give you some tips at the end of this about how you find a legitimate home care agency and what to look for. But for the purposes of this presentation, we're talking about caregivers who are directly hired by a family. Okay, next slide, please. Okay, so people contact me, and I don't know if it's because I'm a lawyer, but they want to argue. Okay, they'll the first thing they'll say is, well, we 1099 a caregiver, and I just say, stop right there. You cannot 1099 a caregiver. Caregivers are never independent contractors. They are always employees of someone, whether it be a home care agency or the family who's employing them. So it's sort of like, you shop for the doctor who tells you what eventually you want to hear. It's sort of the same thing with lawyers. Like, somebody wants them to say, oh yeah, you can 1099. You cannot. So caregivers are an employee under both federal and California law. How do we know that? Well, because the law presumes that you exercise a requisite level of control over how the caregiver does his or her job. So let me give you an example. If my computer doesn't work, I'm going to bring it to a tech shop and say to the guy, fix it. I'm not going to tell him how to fix it. I'm just going to say, fix it, and it gets done. That is not the same as when you hire a caregiver. You can't just say, care for mom, have a nice day, let me know how it goes. Okay, you're going to say, mom eats this, she doesn't eat that, she likes this, she doesn't do that, she goes to the doctor, she does this. You give a level of instructions. And especially now in California, if any of you have heard about the ABC test, it is a new test. It is extraordinarily difficult to classify anyone as an independent contractor in the state of California under the ABC test because of A, the level of control, B, families, household people. It's presumed to be in the usual course of business to employ someone to care for either the household or members of the household. And this is not an independent trade or business. So for all those reasons, caregivers are an employee. And if anyone doubts you on this, you can refer them to California publication DE 8829 or IRS publication 926, confirming the caregiver's employee status. Next slide, please. Okay, so the only time you don't have a caregiver as an employee, and I'm not talking about home care agencies, is if the person providing the care is a parent, spouse, or child. Then they're not covered by the wage and hour laws, minimum wage, overtime. And if it's a parent, spouse, or minor child, you don't have to pay taxes on any compensation you pay to the person. So the easy way to think of this is, I am not talking about immediate family members here. Parent, spouse, child, generally speaking, don't worry about them. They can provide whatever care you want, and they're not required to be an employee. They can be, of course. You can treat them as an employee if you'd like, and some people do that in an effort to show income for that person, build a credit history, etc. There's no prohibition against treating them as an employee, but parent, spouse, child, not covered by wage and hour laws. So if you uncover a situation where a spouse is caring for a parent, that I'm not worried about that. Although it can get sticky, and listen, you folks know this better than I do, it can get sticky when there are multiple siblings, because the sibling who, the child who renders the care often will say, hey, I should be paid for this, I should get a larger share of the inheritance. Sometimes it is simply easier to formalize that into an employment relationship so that you can monetize exactly what the child who's providing the care is earning, and you can do it by the wage and hour laws, and it makes things very black and white and clear cut. It avoids disputes down the road. So I'm not saying you can't have an immediate family member as an employee. I'm just saying they aren't required to be an employee. Next slide, please. Okay, so continuing the argument, right? People will say, okay, fine, fancy pants lawyer, I have an employee, but I'm not going to get caught, right? Because I'm not up for the attorney general's post, or I'm not some top CEO or whatever. And you know what? We love our caregiver. We treat her like gold every Christmas. We give her, a bonus, We would never, she's like family. I hear that all the time. She's like family. We would never end things poorly. And my response to that is, things are always good until they're not, okay? But the most common way that people get caught employing somebody under the table, i.e. not paying taxes on them, not adhering to other wage and hour laws, is unintentional. 9 times out of 10, maybe even higher, the most common way someone gets caught is when that caregiver, her job ends, either because the person gets better, the person moves in with family, moves into a home, passes away, whatever it may be. That caregiver generally lives paycheck to paycheck. She still needs to pay the rent. So what is she going to do? She's going to file for unemployment. And then you're going to get caught. Or maybe she's injured. She's going to file for workers' comp. She's going to file for Medicare, Medicaid. She's older and she's going to file for Social Security benefits. Any of these sorts of things, she's going to list you as the employer and you're going to get caught. And guess what? It's really not terribly damaging to her, because her taxes, even though she probably hasn't declared the income and probably hasn't paid taxes, her taxes are going to be negligible. Your taxes are going to be considerable. And in fact, I'm going to get into this later, that your taxes, your burden actually will be significantly higher if you don't pay those taxes. So filing for governmental benefits. And then of course, if either party is audited, the IRS is going to ask, hey, where is this money going every single week in the same amount? Or who is paying you this money in the same amount every single week? Or I've had cases where the caregiver threatens to blackmail the family. What does that mean? Well, the caregiver realizes that she's going to pay very little in taxes and you're going to pay a lot more. Or maybe, for example, I had a guy who was up for a CEO position with a publicly traded company. It was an 8-figure job. And the caregiver said, you know what, you're going to pay me a lot of money, or I'm going to blow the whistle on you that you've been paying me under the table. And yours truly did like 3 years worth of back taxes over a holiday weekend and got everything straight in order to avoid this mess. So I'm telling you right now that there are many, many ways where you can get caught, even if you're not some high-level person or running for office or what have you. Next slide, please. Okay. All right. Oh, good. So I was looking in the chat, but I see that we have a question in the question and answer section. So that's cool. Normally, if we can put the questions in the chat, that I think is a little easier to monitor. But I want to read this question, and I love this. Seriously, please interrupt me. I was actually getting lonely here. I was feeling like maybe people weren't actually tuned in because I wasn't getting questions. So here we go. And this person writes, I helped hire a live-in personal assistant for my aunt. My aunt was the employer and paid $700 a week. My aunt only needed minimal assistance. My aunt died. The assistant sued her estate and me as a joint employer. How do I defend myself? I did write a few checks to help pay the assistant. Boom. Okay, this is perfect. So not for the situation's not perfect, but this is what I encounter all the time. So under California law, anyone who controls or exercises any control over the hours, wages, or working conditions of a domestic employee is liable for any sort of wage and hour infractions, including failure to pay minimum wage, failure to pay overtime, failure to provide room, meal periods, rest periods, etc. So in this instance, I would tell you, okay, where the person says, I did write a few checks to help pay the assistant. Okay, well, obviously you were involved in somehow exercising some control over the compensation of the assistant. And if you helped hire her, you oversaw her, you controlled what she did, then you're going to be liable as a joint employer. And so in terms of how you defend yourself, you'd have to analyze how you paid this person, the hours that the person worked, and was there any recording of meal and rest periods? What's the overtime due? This is the sort of stuff I do all the time. I'm happy to have you contact me after this webinar and we can talk about this, but I do this all the time. And the chronology here is classic, because everything was fine until the person passed away. And then the lawsuit happened. And that happens all the time because there's often a bond between the caregiver and the person receiving care. And when that bond goes away because the person passes away, then the caregiver is sitting at the bus stop and the bus rolls by with 1-800-THE-LAW-2 on it. And she calls and they say, you could get a lot of money. And the person who she cared for and loved is now passed away. And maybe the children of that person were a pain in the neck to her anyway. And she sues. So I can tell you that this is very common. I can also tell you that, especially with live-in employees, this can be exceptionally dangerous. You can run into liability easily into the 6-figure range. So please, if anybody else has other questions or comments, type them in the chat, not the question and answer. Okay, but yet I have another question in the question and answer. So I'll tell you what, I'll do this other question in the question and answer, and then I got to get back to my program. So this one says, Caregiver who unilaterally moves into patient's residence. Oh, this is going to be a fun one. Representing the patient, I've had caregiver sign a statement that caregiver's presence at the residence is merely to assure patient's care and creates no right of tenancy, occupancy, or other interest in the real estate. Never had to test it in court. Without knowing the specifics of my drafting, is that likely to obviate having to bring an unlawful detainer case to remove the caregiver? Excellent question. I defer all real estate questions to real estate lawyers. I don't know beans about real estate issues involving caregivers, except to say that it is not my area and therefore I cannot speak about it. I will tell you that there is language I include that I've had approved by a real estate attorney in an employment agreement for live-in caregivers, similar to what you're saying, that there's no right to tenancy, that the ability to remain in the home is only based on the duration of the at-will employment, et cetera, et cetera. So I would tell you that it sounds like what you're doing is right, but you definitely would need to consult with a real estate attorney before I can bless that, or before you can use that. Okay, it says, if a spouse or children are receiving IHSS hours, are they exempt from taxes? Okay, so we're getting into the weeds here a little bit, but I want to talk about this. And first of all, I love this. I hope I get into like, I hope I get no more than 3 slides in for all I care. I want to answer your questions, okay? So IHSS is it's a California program called In-Home Support Services, okay? And it is a program designed for people of limited means to have caregivers come into their homes and provide care for elderly or disabled individuals. In this case, to answer your question, if a spouse or children are receiving IHSS hours, are they exempt from taxes? They are employed by the state. So the state will pay them and deduct the taxes. They are not exempt from taxes, but they are simply employed by the state. It has nothing to do with what I'm talking about here, okay? Are the rules the same for a housekeeper who works 4 hours a week and has multiple other clients? Okay, I love this. Now, we're talking here about caregivers. I am not trying to do a presentation about other people who work in the home, housekeepers, gardeners, etc. Okay, but to answer that question, if you hire an individual, it doesn't matter. Okay, it doesn't matter how many hours a week the person works for you. It doesn't matter if they have other clients necessarily. The question is, what level of control do you exercise over how the person does her job? And in fact, Jose, if we can go back for a second, one slide, back one slide, back another slide, please. One more. There we go. ABC test. So it all, whether or not you have an employee, all goes back to this ABC test. What is the level of control you exercise? Is this, so again, the presumption is that you exercise a level of control over someone who comes into your house and does work in or around your house. Is this in the usual course of business of the home? A housekeeper certainly is. And is this an independent trade or business? Now that one probably, in your example, cuts against the employee status if the housekeeper says, I have my own independent trade or business. I would feel much more comfortable, however, if you were in fact retaining a service like Mary Maids or something like that to clean your house. I would tell you, therefore, you certainly don't have an employer-employee relationship because you're contracting with a service. The service is the one who pays and supervises and controls those employees. You don't even decide who the employee is who comes to your home or what that person does. Mary Maids does. And I'm just using Mary Maids as an example. It could be any housekeeping service. That I don't worry about. But if you employ Susie Smith to come to your home and you tell her what to do and when to show up, then I would tell you, you are probably the employer of Susie Smith, at least for wage and hour purposes, okay? Which means minimum wage, overtime, meal periods, rest periods, okay? And then as to whether or not you have to pay taxes, there are thresholds on the amount you pay. If you pay more than $750 and a quarter, and I think it's, off the top of my head, I think it's more than $1,500 in a year. If you cross either of those thresholds, you also have tax responsibilities in addition to the wage and hour responsibilities. Okay, Jose, let's go back to where I was. Keep going. Keep going. Okay, stop. All right. So continuing along with the let's argue with the lawyer sort of thing, the next thing people will say is, okay, fine, I have an employee. Fine, I could get caught. So what? So I'll just pay the taxes that I should have paid in the first place, right? Oh, wait, Jose, can you go back one? There we go. Okay. So the answer is no, that's not the way it works. You can't just be like, oh, sorry, here's the money I should have paid in the first place. No, because here's the deal. As an employer, your tax burden is about 9%. Okay. And that's your share of Social Security, Medicare, and state and other ancillary taxes. That's what you pay. So if you pay somebody $100, your cost is going to be $109 roughly. Okay. And similarly, there's about a 9% payroll tax burden from the employee. That's the employee's share of Social Security, Medicare, and state disability insurance. Well, guess what? The government says you as the employer are the more sophisticated party here, and you are required to withhold those payroll taxes, not personal income taxes, state or federal, but payroll taxes. You're required to withhold those. And if you don't withhold those, you then pay them on the employee's behalf. So what happens? You've just doubled your tax burden, plus you've got penalties, plus you've got interest. And then having gone through these meetings, I can tell you that the IRS will also tell you, hey, you report and pay your federal household employment taxes on your personal income taxes, which you happen to sign under penalty of perjury. So you've also committed perjury and tax evasion, okay? Not to mention the reputational and career issues. Next slide, Jose. And by the way, if you're licensed by the state for anything, whether it be doctor, lawyer, architect, engineer, whatever, if you are even charged with a felony, which by the way, federal tax fraud is, you're required to notify that licensing authority. So in this case, the state bar wants to know. I've also had the IRS and taxing authorities say, did you tell your caregiver not to tell anybody about this? Did you tell them they can handle their own taxes, but they don't have to worry about it? You just engaged in conspiracy. Mother of God, I've been to these meetings and it's sort of like Elliot Ness. You're like, oh, I can't believe you just said that. Like, and you can see the blood drain from your client's face. Not to mention the professional fees. I always joke that you can pay me a little bit of money to help you do this right, or you can pay me a lot of money to defend you if you've done this incorrectly. Okay, so please, I'm begging you. And also, lastly, your peace of mind is worth something here. I mean, without exaggeration, I get at least one call a month from somebody in tears who's worried about losing the house because they didn't pay the caregiver correctly, and now they're being sued. I mean, like it's nuts. I've had people wait. Like there are lawyers out there who specialize. It's like caregiver overtime and other things, specialize just in taking caregiver claims, and they'll wait for like if the person who passed away is Jewish, they'll wait for the mourning period and then they'll file the suit. It's crazy. There are rapacious people out there who will fight for your caregivers, and it will quickly add up to a lot of money. Another chat question: can I set up my caregiver in her own company? No. That does not mean just because the caregiver has her own business, ABC Caregiving, for example, that all of a sudden it transforms her not from being an employee to an independent contractor. Why? Because under the ABC test, you're still exercising a level of control over how she does her job. And that level of control is what primarily determines that you have an employee, not an independent contractor. Okay, you are hiring one person to do a job for you, and you are directing them in that work. That means you have an employee. And you can say, it's really ABC Caregiving, but if everything else remains the same, that is not going to be sufficient to somehow vault you out of the employer-employer relationship. Believe me, this is a dead to right sort of issue. It is not worth arguing about. If you have a caregiver in the home and she's not employed by a home care agency, she is, without question, your employee. Next slide. Okay, now I don't mean to be the Charlie Brown rainy cloud on an otherwise sunshiny day. There are many advantages to hiring legally. For the client, okay, now understand this. If you run a business, you can deduct the salary of your employees. Everybody understands that. There is no such deduction for household employees. So you can't just write off, I get this question constantly. You cannot write off what you pay them on your taxes. It's not, you even though you look like an employer because you follow the wage and hour rules and you have tax issues, you cannot write off their stuff. The people will say, well, what about the medical issue? Can you write off the caregivers if the medical expenses exceed a certain percentage of the gross income? I'm not talking about home health care here. I'm not talking about nurses. I'm generally only talking about non-medical caregivers, those who provide companionship, supervision, and assist with household tasks. Generally speaking, these sorts of caregivers are not eligible for that medical exemption that some people have raised. Typically, the only advantages are if you can declare the person receiving care as your dependent, you can access a dependent care account and put money tax-free into it and withdraw it tax-free out of it. You can also access the federal child and dependent care tax credit. These things work very well if you have a nanny caring for your child. They are generally not applicable to an older person unless the older person happens to be your dependent. There are advantages for you though, because cash flow, I mean, if you are withholding taxes, your outgoing cash is lower. If you pay somebody $500 a week with no taxes, you're out $500 a week. If you withhold taxes, you're maybe only out $425 a week, and that $75 you remit to the government. So your cash flow is a little easier. And like we said, I can guarantee all of you on the call, if you are on this call, you are aware of these issues, your peace of mind alone is worth this. Next. Okay, there are substantial benefits though for the caregiver. The caregiver gets access to a wide variety of governmental benefits: unemployment, Medicare, Medicaid, Social Security, state disability insurance. The caregiver also builds an employment history and establishes credit. So like in our example, like we had a nanny, she was going to buy a condo with her boyfriend. The only way she could do that is by showing W-2s and income from us. Also, many caregivers don't earn that much money. They will also qualify for the federal earned income tax credit. Really, the way to sell this to the caregiver is some caregivers are opposed. They don't want to do taxes. And let's just step back and say taxes aren't optional. I can't go to Target and say, I'm feeling a little light today, let's hold the sales tax. Like, you got to pay taxes. It's not optional. However, many caregivers will say, well, I don't want to pay taxes because I'm getting child support, or I'm getting alimony from my former husband, or I'm qualifying for some sort of state assistance, food stamps, subsidized housing, welfare, whatever it is, and I don't want to show that income. I have no patience with these people. Ethically, it's completely unethical. And I had a client years ago say to me, I was trying to convince her all the reasons to do it legally, and she cut me off and she said, Bob, if my caregiver is willing to lie to the government about taxes, what is she willing to lie to me about? And I thought that was such a telling statement and really smart. And so I would tell you that your caregivers have substantial benefits to declaring their income and working legally, and you should remind them of that. Okay, a couple more questions in the chats. Do you have any suggestions for families hiring caregivers through an agency to make sure the agency is abiding by wage and hour rules, taxes, insurance, to protect family from being included in a claim as an employer? That's excellent. And yes, I do. And I'm going to get to this at the end of the presentation, but I'll tell you this right now. Under California law, home care agencies are required to be licensed with the state. So any agency that employs their caregivers should have an HCO number, home care organization number. Okay, so you should ask for that HCO number and verify it with the state. It's the California Home Care Services Bureau. Now, HCSB, Home Care Services Bureau, doesn't necessarily check for wage and hour compliance, but they do audit home care agencies for a wide variety of licensing related issues. And I would tell you that generally speaking, if they comply with the HCSB licensing issues, that's a good sign. Does it guarantee you that they're following all the wage and hour rules? No, you'd have to dig into that yourself. That's a little bit more complicated. We're going to go through those rules here. But at a minimum, I would verify that they have an HCO number and are licensed by the state. Okay, next question. If time permits, kindly give us guidance about what constitutes full-time versus part-time employment. At what number of hours does time and a half or double time hourly compensation kick in? I will absolutely do that. That is part of our presentation. But just so you know, full-time versus part-time employment is irrelevant. They're either your employee or they're not. So full-time versus part-time doesn't matter. But overtime certainly does matter, and we're going to get into that. Next slide. Okay, so we talked about this. The extra cost of hiring legally is roughly 9% for the employer. If you can qualify the person receiving care as a dependent, it's only roughly 4% more. This is a small price to pay. It is not going to break the bank. It truly is not. And I'm sorry, I'm going to go quickly through some of these slides just because I want to make sure we get through this. Next slide, please. Okay, so that sort of concludes the tax piece of it. I want to now go into the wage and hour piece just so we have a sufficient time on this. So caregivers working in a private home are governed by California Wage Order 15 and the Federal Fair Labor Standards Act. It's both of them. Okay, and sometimes people only look to California laws, but the FLSA also has important laws that bear on the situation. Next, please. Okay, here's the holy grail. You want to make sure your caregivers are qualified as personal attendants, and they are personal attendants if they spend at least 80% of their time supervising, feeding, and dressing an elderly or disabled client, and they work in a private home. Again, I am not talking about people who perform medical tasks. Medical-related tasks are outside of this 80%. I'm not talking about nurses. They are not personal attendants. I am only talking about non-medical companion sort of caregivers here, okay? So, but being a personal attendant is incredibly important because it avoids most wage and hour requirements, not all, but most. So the main thing is, please try and follow these guidelines, 80% supervising, feeding, dressing. And when I say supervising, feeding, dressing, ancillary activities are arguably also part of that. Now, the Labor Commissioner's website narrowly defines the supervising, feeding, and dressing, but court decisions and prior Labor Commissioner opinion letters more expansively define supervising, feeding, and dressing. So I will take the position that feeding also includes making the meals and cleaning up. Dressing also includes doing the laundry, okay? The Labor Commissioner's website, which by the way has no force of law, has a more crimped definition of this. So it's not a slam dunk, but you at least want to adhere to the 80% supervising, feeding, dressing as much as possible, focusing on the client. Next slide, please. Okay, so these are your danger areas where you could lose the exemption. If that caregiver spends more than 20% of her time on housekeeping, you're going to lose the exemption. Okay, so if you are hiring a maid, they're not a personal attendant. So please be careful on housekeeping. Please be careful on facilities. If you have a caregiver who goes into a facility, i.e. anything other than a private home, they are not a personal attendant, okay? And I'm going to get to why that's so important, but please, I'm begging you, be careful about this. And this is not only hospitals and nursing homes, but assisted living facilities, even independent living facilities. I would argue an independent living facility is a private home. Those apartments look like private homes. They have doors that lock. They have their own kitchens. They look like apartments, right? They look like private homes. But the DOL has said, no, 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 because if you really bear down on these things, they don't actually look like private homes. And the reason is there's often limitations on the number of visitors, when visitors can come, what you can do to the unit. They have right of first refusal for sale. There are all these conditions that sort of undermine the private home. So please be careful in terms of, is this really a private home? Because if it's not, they're not a personal tenant. And again, any medically related activities are not within the 80%. You're going to lose the exemption there too. I will also say, please be careful about any able-bodied other adults in the home. The running joke is nothing good can come from the fully grown adult son living with his mother. Because what happens is your caregiver is all of a sudden going to be making meals for the son, doing the son's laundry, cleaning the son's room. And if she spends more than 20% of her time outside of duties on the senior, you're going to lose the exemption. So please be careful when you analyze these situations of, do I have a personal attendant or not? Is there anyone else in the home who's able-bodied? And make sure that caregiver isn't doing anything for that person, or you could potentially lose that exemption. Okay, next slide, please. Okay, so please, caregivers are non-exempt employees and must be paid hourly. So like in the first hypothetical I received in the question and answer, they said, well, we paid the person $700 a week. That is the single most expensive mistake you can make if the person earns overtime. You cannot pay shift rates, day rates, overnight rates, weekly rates, or monthly rates to non-exempt employees. They must be paid hourly. And if you do pay sort of a flat rate to an hourly employee, under California law, that flat rate can only cover the straight time wages. You get no credit at all for overtime wages. So what does that mean? Well, you pay somebody $1,000 a week and you say, it's salary. I'm going to work them as much as I want. I don't care. I work them 50, 60 hours, whatever. Say I work them 60 hours, but they're getting $1,000 a week. They'll be fine. Note, what happens is you have the 40 hours in the week, okay, as the straight time. And I get my calculator here, 1,000 divided by 40. comes out to an hourly rate of $25. That's an overtime rate of $37.50. You get no credit for overtime. So what did you just do there? You, by paying what you thought would cover everything, only covers the straight time wages. You have an enormously high rate for the straight time wages. So then your overtime rate is 37.5 times, let's say 20 hours extra. You owe $750 that week. 20 times 37.5 because you get no credit for the overtime hours. Think about that on a 3-year or a 4-year statute of limitations, depending on the amount of the claim. Okay, that's easily gotten into 6 figures right there, just on what you owe. So please don't pay. Think of these people as somebody who's not exempt in your office or the cashier at Target or whatever. They must be paid on an hourly basis. Next. Okay, so here are the overtime rules for personal attendants. And again, most caregivers are personal attendants, so this is not a terrible stretch, but it is something you have to be careful about to make sure they qualify as personal attendants. Caregivers who are personal attendants, whether for nannies or for caregivers for elderly or disabled individuals, are entitled to overtime after 9 hours in a day and after 40 hours in a week. 9 and 40, okay? 40 straight time hours in a week, okay? Those are your goalposts. The only exception is if the caregiver is employed directly by the family and lives with the family, then overtime kicks in on a weekly basis after 45 hours. Now, many of you will say, oh, but I've just read, I had a client say this to me today. I read under California law, it's 9 and 45, after 9 hours in a day and after 45 hours in a week. Why do you say 40? And I say 40 because federal law requires it. You can't just look at California law, and whatever law is more beneficial to the employee applies. So therefore, it's 9 and 40. Next. Somebody asked if there's a recorded version of this. I know we are recording it. By all means, if you've got, and you can always call or email with questions. Understand you'd have to retain our firm if I'm going to provide you with legal advice or follow-up questions, but by all means, contact us. So live-in caregivers. Okay, I get this all the time. Okay, and I always worry when a client calls me and says, oh my gosh, we are so generous to our caregiver. I'm always like, okay, here we go. Oh, they live in a beautiful Malibu beach house and they ride around in mom's Mercedes and we take them on vacation. And I know as soon as they start telling me that they're underpaying the caregiver. 100% of the time, it happens every single time. So please, for a live-in caregiver, if you require that caregiver to be there, you must pay that caregiver for all hours they are there, including sleep time. You cannot deduct sleep time. You used to be able to deduct sleep time. And in other states, you can deduct sleep time, but not in California. So if the caregiver is there in the home, oftentimes I'll get this. They'll say, well, yeah, the caregiver's there, but she's not working. She's sleeping. Can she sleep in her own bed? Oh my God, no. Mom gets up in the middle of the night. She could fall. Okay, then you have to pay her. If that caregiver can't sleep in her own bed or go away overnight or go to Denny's because the 2 a.m. Grand Slam is calling her name, if she can't do that, you must pay her for that. And let me tell you how expensive that is. The current minimum wage in California is $15 an hour for employers with 26 or more employees. For smaller employers, i.e. most household employers, it's $14 an hour. However, different localities have higher minimum wages. I'm just talking about the state minimum wage. So let's play this out. $14 an hour. Let's assume the state minimum wage applies. The first 9 hours are paid at $14 an hour. The next 15 hours are paid at $21 an hour. That totals $441 per day before weekly overtime even kicks in. So $441. So you will see plaintiff's attorneys say, hey, are you a live-in caregiver? Are you earning less than $441 per day? Then you have a claim. And they're right. So please, for live-in caregivers, either define their hours worked and say expressly in the employment agreement, hey, look, when you're not working, you are free to come and go as you like. You're not required to be on property. You're not required to respond. You're not required to be on call. You are totally out of our control and you do whatever you want. Fine. Or if you do require them to be there, know that you have to pay them at least $441 a day, which is why most people don't staff 24 hours. They'll staff to 12 hours. Got another question in the chat. Will you be explaining the rules for a caregiver that is not a personal attendant, e.g. a companion who visits a resident in a board and care home? Probably not, because those rules are much more, they're more complicated and they're more expensive. I may have a slide on that, but I'm warning you that those rules are the same rules if you employ, say, like a receptionist in your office or somebody at Target or whatever, but you've got meal and rest periods, you've got overtime in a greater variety of circumstances, you have double time, everything else. I'm talking here primarily about caregivers who are personal attendants, but if I have time, I will go into the non-personal attendant rules. Next slide, Jose. Okay, so these are alternatives to 24-hour staffing because it is so obscenely expensive. Most people would staff it as 2 12-hour shifts. Many people use technology. Technology today is wonderful. I mean, you can determine if somebody is sleeping or awake, if they're laying down or they're sitting up, what they're doing, et cetera. So, do you really need someone there staffed overnight? Obviously, if they're a fall risk, of course you do, but otherwise maybe not. Next slide. Okay, so legally, the safest course is to prohibit that caregiver from remaining in the home during non-working hours. But as I said, there are practical difficulties to that. Maybe the caregiver doesn't have her own home. Maybe it's a long drive. Maybe she doesn't have a car. Maybe it's just easier for her to stay overnight. If you truly don't need them, you have to have language saying all the things I said, that they're not on call, they're not working, they can leave the premises, et cetera, or you should pay them for their entire time. Next. Okay. I just want to caution you on this. I don't need to get too in the weeds on this, but I'm warning all of you. If you pay different rates of pay to the same employee in the same work week, you have weighted overtime. You cannot just pay time and a half, whatever the rate is in effect, okay? You have to average the number of straight time hours and the total amount paid for straight time to come up with the actual regular rate for the overtime calculation purposes. This doesn't, many people would say, why would I pay different rates, right? And the answer is, well, maybe you're calling them in at the last minute. Maybe it's like all of a sudden they need to care for somebody else, or there's all of a sudden something got more difficult or what have you. Home care agencies, if there's any home care agencies on the line, I know you all pay different rates of pay in the same work week for a wide variety of reasons. This is one of the most common things that home care agencies get sued for under class actions and the California Private Attorney General's Act. So please be careful of this. Next slide. Okay, here's what's not required for personal attendants. You never have to pay double time. You don't have to provide meal periods. You don't have to provide rest periods, okay? These things are required if they're not personal attendants or they're not working in a private home. But if you've got a personal attendant working in a private home, i.e. the most common type of caregiver, you just have to provide overtime after 9 hours in a day and after 40 straight time hours in a week. That's it. Unless they're a live-in caregiver, then it's 9 and 45. Next slide. Okay, so we talked about this, the minimum wage, 15 for larger employers, 14 for smaller employers. For those of you on the line, you can't salary a caregiver, but for those of you on the line, understand that if you have salaried exempt employees in your businesses, when the minimum wage goes up, so does your minimum salary. So I often get people saying, oh yeah, so-and-so is an exempt employee in my office. I pay her $35,000 a year. She is not an exempt employee at that salary because that salary is not twice the minimum wage. So be careful. Are itemized, I get another question, are itemized wage statements required for personal attendants? That's an excellent question. And the answer is no. Because under the labor code, household employers are not required to provide pay stubs. You can if you want, but if you are a domestic employer, you are not required to provide them. Next, please. Okay, I'm not going to read all this, but this is the local minimum wage ordinances. So remember how I said it was $15 an hour and then it was 14 for small employers. But if you have employees in any of these jurisdictions who work more than 2 hours a week in any of these jurisdictions, you should look at them more closely because you've got a higher minimum wage. Okay, so please be careful. I know we are, like, it's funny because I'm in Orange County. There's not a single jurisdiction in Orange County, San Bernardino, or Riverside counties that have higher minimum wages. But in LA County, you bet, and in San Diego County, and et cetera, et cetera. So please take a look at this list. Next, please. Okay. Right, and so these overtime and minimum wage requirements apply to all employers, agencies, as well as families. It's not like just because you're a family, you can avoid the minimum wage or the overtime. Next. Okay, so there's very little savings for a family on the hourly wages because you have to pay the same wages that the home care agency does. However, obviously the home care agency charges a profit margin, right? They need to make their own margin. So that's your savings. And again, it's up to you. Like, I'm originally from Massachusetts, and there we had a 1/4 acre of land. I had a riding lawnmower and I mowed my own lawn. Here I live in Orange County. I have a lawn the size of a postage stamp, and I have a gardening service that does this. And it's crazy. I get all kinds of grief from my cousins back at home, and they're like, "What are you doing?" And the answer is because I don't want to mow my own lawn. And it's the sort of same thing here. If you need home care, you can do it yourself, or you can pay an agency to do it. If you pay an agency to do it, you're going to pay more, but you get what you pay for. It's all up to you. You can save money doing it yourself. It's just, do you want to? Next. All right, so please, there's no way to get around these rules. You cannot, I've heard all of these. You can't salary these caregivers. You can't 1099 them. They're not independent contractors. They can't volunteer their time. I hear this one. Oh, so-and-so, the caregiver just loves mom, loves her. So she works for mom Monday through Friday, and she just volunteers her time and spends time with her on the weekend for free. No. If she's doing the same thing, she's not a volunteer, you have to pay her. And by the way, I see this at least several times a year. You cannot mutually agree to waive overtime. Lawyers are funny. They'll write these things like, "Oh, I understand my right to overtime and I voluntarily waive it." That's irrelevant. It's unenforceable. You can't do it. Same with the minimum wage. Can't waive that either. Can't waive your right to be paid for sleeping, time, sleeping time, etc. Can't waive any of these things. They're all required. Next. I got less than 5 minutes, so I'm really trying to motor through this. Okay, understand this. Household employers also must provide paid sick leave. Okay, an employee accrues 1 hour of paid sick leave for every 30 hours they work. Next. They have to be employed for at least 90 days to start using that sick leave. And here's, if you have a policy, and you must have a policy saying this, you can limit the use of paid sick leave to 24 hours per year and the accrual at 48 hours. Okay, so what does that mean? That means they can earn 24 hours, use it, then build up 48 hours again in the bank. Okay, that doesn't mean they can use that 48 hours until the following year, but on January 1 of the following year, then they get to use that 48 hours or that 24 hours according to your cap. Okay, so caps, use cap 24, accrual cap 48. Next slide. Okay, and you can also require that it can be used in increments of no fewer than 2 hours. So they can't like leave 15 minutes later, 15 minutes before they're supposed to their shift end, say, cough, cough, I want to use my sick leave. No, they have to use it in 2 hour increments if you have it in a policy. Okay, all of these things though can only be enforced if you actually have a sick leave policy. So when I do an employment agreement, you should have a sick leave policy that covers these issues. Next. Okay, there are some jurisdictions that have local sick leave laws that are more generous than what I just outlined to you. They're listed here, including LA and Santa Monica, so please be careful about that. Next. All right, so I'm going to close with this because I really don't have a lot of time, but I want to make sure we get to this. So you may encounter things called registries or DRAs, direct referral agencies. They look like home care agencies. They are not home care agencies. What registries, DRAs, or employment agencies do is they refer a caregiver to you, but then you as the family are still the employer. They will invoice you for the caregiver's wages. So it looks like you're dealing with a home care agency, but in fact, you have all the employer responsibilities. But the DRA, because they're not the employer, they don't have the cost of the employer, so they'll be cheaper than a home care agency that's licensed by the state, for example. But for the unsophisticated consumer, it looks like you're dealing with just two home care agencies. They probably even have similar names. You don't know the difference. So I implore you, if you are considering hiring an agency, know what you're getting into. If you want to use a registry because they're cheaper, that's fine, as long as you understand that you will have employer responsibilities. And that registry is required to disclose to you both verbally and in writing that you are the employer. Frequently, unfortunately, they don't. So you don't know. But the easiest way to get around this is to ask for the HCO number of the home care agency and verify that with the state online on the state's website at the Home Care Services Bureau. Because the state does not license registries. They only license home care agencies that directly employ the caregivers. Next slide. Okay, so please ask for the agency's HCO number. Next slide. And be careful if you're going to use a DRA. There's a small savings. To me, I'm not a huge fan of this model. I would prefer that a family either direct hire, okay, or use an agency. The DRA is sort of in the middle. Their pricing is in the middle. but you still have all the employer responsibilities. All you're doing is the DRA is finding you somebody, which is helpful. But if you're really are you really going to keep paying for that person over and over again with the DRA? That's where I question the utility of that model. Also, by the way, I'll touch on this briefly. Everyone is required to provide workers' compensation insurance, including family employers. That's the bad news. The good news is, under California law, homeowners insurance policies are also required to offer workers' compensation for household employees. So if you run into a situation where there's a caregiver in the home, please call up the homeowners insurance company, make sure there's workers' comp coverage for that caregiver. Of course, if you hire an agency, the agency will take care of that. But if you're directly employing, please make sure you got workers' comp coverage in place. Next slide. Okay, so we talked about this. Next slide. Okay, we talked about this. This is more DRA stuff. Next slide. Okay, so this is our contact information. You can call or email. Again, if you have follow-up questions, you want to schedule a time for a consult, I'd be delighted to talk with you. I'm an evangelist, okay? I help people do things legally. All of you on this call are involved in home care in one way or the other. It's noble. You help people remain in their homes with dignity and independence. I play a tiny, tiny part in that by helping you hire caregivers legally or defending you if things go wrong, whether it's from a tax or more likely a wage and hour standpoint. If we can help you on this mission, I want to do that. Next slide. I don't send out newsletters that often. I don't have time to write them. You don't have time to read them. I maybe do one once a year. I did do one earlier this year. So if you want that, please, let me know. But the best way to keep up to date on all the legal and issues affecting household employers is to follow us on social media, Facebook, Twitter, and LinkedIn. That's the way to do it. I am out of time. I thank you for being here. I am immensely grateful to Terry Magedy, the Beverly Hills Bar Association, and everybody for the privilege of your time in talking to you about this important subject today. Thank you so much.
Comes right back at you, Bob. We're tremendously grateful too. I mean, great, tremendous presentation. I see we got 91, 92 people listening. So pretty much guaranteed you're going to get some calls. Great, tremendous information. Thank you so much. See you next time. Hopefully we won't wait however long we waited last time. We'll get you back.
I'm going to do one more. I'm going to do one more. There we go. I got the screen. All right, everybody smile. 1, 2, 3. Thank you. Okay. We're good. You'll be on my social.
Bye, everybody.
See you guys.
See everybody at the next program.
Okay.
Bye-bye.
Bye.